We're live, Mr. Chairman.
We're all set. All right, committee. We got two bills here to work on. One of them we got started on last week, and by a suggestion of one of our members here, I think we'll go into that one and I'll do that. And then once we take roll call, we'll get started into that. Go ahead, Clayton.
Senator Craigo.
Here.
Senator Love.
Here.
Senator McEwen.
Here.
Senator Pearson.
Here.
Chairman Ide.
Here.
We have a quorum.
Okay, the first one that we got, we'll work on today is Senate File 84, Voluntary Water Conservation Program. And I think Senator Boner presented that to us, if I remember right, last Thursday. And we kind of got started with some public comment. Is there others that would like to comment on Senate File 44 today? 84, excuse me. Yeah.
The comments on both.
Go ahead, Director.
Good morning, Mr. Chairman, members of the committee. My name is Brandon Gebhardt. I'm the state engineer.
And good morning. My name is Chris Brown. I supervise the water section of the Attorney General's office.
So, Mr. Chairman, thanks for letting us speak today. This bill has been in the works since before May. The main reason we brought this bill, particularly with everything going on in the Colorado River Basin, just the terrible hydrology rules and the operating guidelines expiring, all the negotiations going on. One of the things that I believe to be paramount is for our ability to conserve water that works for Wyoming, but could also be plugged into a larger program if one is ever developed. So the two primary goals of us bringing this was, one, it helps avoid mandatory and uncompensated water use reductions, whether by court order or curtailment to satisfy compact obligations. It provides a tool for Wyoming to be part of a compromise to address historic drought that has plagued the Colorado River Basin for the last 25 years. And it provides a compromise with our sister states, avoids uncertain and harmful outcomes from litigation or congressional intervention in a way that can also benefit Wyoming water users. If we were required to take mandatory reductions, we believe that this will help preserve our senior rights. Mandatory reductions put all of our junior water users at risk. This includes the ability to fill reservoirs who have junior rights. It impacts the seconds that our irrigators rely on. It impacts Free River. And many of our municipal and industrial water users would be put at risk of mandatory reduction. If the 7 states that share the Colorado fail to reach a compromise, and we are required to make mandatory water use reductions, we believe that this program gives us a flexible tool that provides water users in Wyoming with some water supply certainty and helps avoid permanent buy and dry of irrigated ag. Those were really the many reasons, but the two primary reasons. And as I mentioned, we started this before May, and it's starting in May, we met with the Select Water Committee. Since that time, we've had 4 meetings with Select Water Committee. We presented once to Joint Ag, and then we've had at least 4 public meetings pertaining to this program, and then multiple meetings with our advisory committee throughout that period. Mr. Chairman, I don't remember, did Senator Boner or Select Water, did they go through the bill?
Yes, they did.
Okay. And I might turn it over to Chris for anything to add on why we brought it or any details of what we brought.
Excuse me.
Yes, sir.
You were right. We did not go over that. We just took public comment and I don't think we actually, nobody really went through the bill as I recall. It's been too long ago, but a lot of mess in between. Anyway, with that question, would you like to go over the bill? I mean, would you like to read through the bill and advise us where you think we need to?
Yeah, Mr. Chairman,
Yeah.
I'd be happy to just kind of step through the bill with some high level descriptions, if that's all right.
Sure, go
So-
ahead.
Let me pull it up here. So, Mr. Chairman, under section 1 on page 1, these are the definitions that are tailored to the Colorado River Basin. This provision describes the process, the application, review, and approval. It describes who can apply and how to apply and allows multiple water rights to be part of a single project. It allows applicants who are not water right owner to apply, such as end users with the right to the storage water. Requires written consent from the water right owner if they are not the applicant. And I apologize, I mashed those two together. First part is definitions. 41.3.18A is what I just described. Moving on to the next provision is the notice of application requirements, 41.3.118B. This requires the SEO to publish notice of applications on its website and to provide electronic notice to anyone who has requested it. And based on some of the additional feedback from our Colorado River Advisory Committee on January 21st, Select Water Committee meeting, we proposed an amendment to bolster some of that notice requirements. That was approved and incorporated in this bill. Since that time, we have had more discussion with people concerned and interested about the notice requirements. So I do have an amendment to address some of those and some of the conversations we had. I believe the folks we were talking to are comfortable with the amendment, so I can present that later after I go through the bill. This section of the bill also says that prior to a decision on an application, the draft provides the opportunity for water right holders and other users and others who may be adversely impacted to provide comments on the application. 41.3.118D talks about the no injury to other water rights. The proposed conservation projects cannot injure other water rights. This is the same consideration involved in other types of water rights. I will note that injury to other water rights is different than all potential impacts that could be caused by a project. Some of the other things that may not be a legal injury to the water right, but could be impacts are things like return flows to adjacent fields, carry water and shared ditches, those types of things. It provides discretion for the state engineer to deny or reject an application if it appears to be detrimental to the public interest, which mimics existing state engineer authority. And this bill also allows for conditions to be placed on approvals to mitigate the local impacts, such as those impacts that aren't impacts to the water right. Those are the return flows to adjacent fields, carry water. It allows us to mitigate that through conditions placed on the project applications. Next provision of the bill is a shepherding limitation. This bill does not seek the authority to shepherd conserved water. It provides limited authority to shepherd conserved water if the applicable stream is already under regulation. The next provision is the consumptive use considerations. The bill requires that a water right demonstrate a recent history of consumptive use to participate. It allows the state engineer's office to utilize the uniform methods adopted by the Upper Colorado River Commission unless the circumstances dictate otherwise. This primarily relates to using remote sensing for estimating consumptive use for irrigated agriculture, but limits that method only to this section, and it does not apply to other water right determinations elsewhere. The next provision discusses the irrigation district approval, that any project within an irrigation or conservancy district requires the district's approval. And then we've got next provision is participation limitations. The bill attempts to minimize local impacts that may result from irrigation rights participating for an extended period of time. It limits participation to 5 consecutive years and then requires that the water right be placed back to its original use for at least 2 years before being eligible for the program again. The next provision just protects the participating water rights from abandonment. The next provision defines the appeal provisions. The appeal provisions allow applicants and owners of other water rights that are injured to appeal the state engineer decision to the Board of Control and ultimately the district court. In both cases, which deal with property rights, it provides for a contested case hearing. The appeal provision also allows any other aggrieved person to appeal the district court under the Wyoming Administrative Procedure Act. The next provision just exempts these conservation projects from the export statute. The next provision, or actually the next statute is 41.3.119. This discusses conserved water storage in Fontenelle Reservoir. The bill provides explicit authorization for the state to store conserved water in Fontenelle Reservoir through a contract with Reclamation. Working with the advisory committee, we decided that the bill should limit the purposes for which conserved water can be released to 3 purposes. The first, for exchanges and direct delivery to downstream users in Wyoming. 2, to mitigate impacts of curtailment, either through the UCRC, the Upper Colorado River Commission, or by court order. And then 3, to participate in an upper basin conservation program. Subsection C of this provision authorizes the state engineer to assess the suitability of other reservoirs in the basin to store conserved water and authorizes that storage in suitable reservoirs under contracts with the reservoir owner. The next provision is a request for 2 full-time employees for the state engineer's office to administer and implement this program. One of those we envision being in Cheyenne to assist with the applications and the verifications and all the things that we will be looking at with each of these applications. The other would be actually in Division 4 out in the field, again, to help with applications, verifications, and actual implementation of the projects and the program on the field. Section 3 discusses the finding. It's important to distinguish the Colorado River Basin from other basins in the state. Other basins have different and unique challenges. The goal is to allow the program to operate in Wyoming that will also allow us to participate in a larger upper basin program. However, absent a larger upper basin program, the bill still allows a program to function in Wyoming for the benefit of our water users. The next section allows rulemaking. It provides a broad framework. The bill provides a broad framework to authorize a pilot program with the expectation then that we would develop rules through a public process to provide more specific details of the program. The next section is a waiver of rights, no waiver of rights. Makes clear that by authorizing the ability to voluntarily conserve water, Wyoming is not waiving any of its rights under the Colorado River Compacts. And then the final portion of this is the time limit and reporting. No new applications will be approved after July 1st, 2032. And then it requires a report by the end of each water year to the Select Water Committee with recommendations to continue, change, or end the program. Mr. Chairman, I might ask Chris if he has any color.
Go ahead, sir.
Mr. Chairman, again, Chris Brown with the Attorney General's Office. The only thing I might add, and the state engineer is absolutely correct, that this particular piece of legislation, the state engineer proposed last May to come up in the interim topic, but really this is a product of much longer work. We've actually been working on these issues for over a decade, beginning in about 2014. Really getting involved with water users after getting more involved after the 2019 drought contingency plan that was entered into in the Colorado River Basin, identifying a very large group of stakeholders to start digging into these questions with regard to consumptive use and what are the impacts and what are the issues and what do we need to be thinking about. That stakeholder group evolved into a work group that was created by the governor with members from individual water sectors appointed to act as liaison, bring us feedback from the water user groups, have us understand what the issues are on the ground out in Division 4 in the Little Snake portion of Division 1. That evolved into this legislature, the legislature creating the advisory committee, which also is just a group of representatives appointed by the governor, a representative from the Senate, a representative from the House to further develop these things. So this is really a culmination of a long period of working on these issues to try to move this forward. So just wanted to add that additional color.
And Mr. Chairman, I might just add one other thing, that if we are to get to a 7-state consensus agreement, conservation in the upper basin would be paramount to our ability to get to that consensus agreement with the 7 states. But it also allows us to operate the program even without that consensus agreement as a tool for our water users to provide certainty, particularly the junior users, to provide certainty without that agreement and to mitigate the impacts or maybe even eliminate, probably not eliminate, but mandatory reductions if they were to occur, whether it be a court order or through the compact. So, Mr. Chairman, that's very high level of the bill. And I would like to perhaps offer a couple of amendments that we have had since the January Select Water Committee meeting to address some of the concerns that we've heard from folks. One of them provides 2 definitions to define curtailment and involuntary water use regulation. We had some comments that might provide a little more clarity. And then the other is to address some of the concerns that we've been working through on the notification of the program. And Chris, do you mind just briefly describing what we're?
So, Mr. Chairman, and I'm not sure you're going to, state
Yes.
engineer is going to hand those out, but the main proposed amendment that we're suggesting that the committee considers with regard to notice. And really the concern was, and of course, the Select Water incorporated additional provision with regard to notice to try to make sure that landowners that are immediately adjacent to wherever a project might be know what's going on so that they can understand what potential impacts there might be with regard to their water rights. So that was added in by the Select Water Committee. We were working with stakeholders primarily related to irrigated ag about what additional notice there might be. And so just walking through what we have, what we're putting forward, a lot of it really is on the front end to really try to make sure that stakeholders in the basin are aware of the program, what the program is, provide them an opportunity to learn with regard to what the program might be. So I believe the state engineer has handed you the proposed amendment. So this would offer a new subsection B, starting on page 5, line 5, and really for the purpose of providing notice of the program and conservation project applications. It provides for notice to be published in at least 3 newspapers for 3 consecutive weeks about how water right owners or other interested persons can obtain information with regard to the program. It also requires within 90 days of the effective date that same kind of notice be published in 2 Wyoming trade publications related to irrigated agriculture to put folks on notice. And we would anticipate that we would also notice up what's contained in the third subsection B3. Within 120 days, the state engineer would have to hold at least 3 public meetings at different locations, again, just to bring awareness with regard to it, with regard to the program, so folks can understand what it is and where to find additional information. And then under subsection 4, under the previous amendments, the bill had required that folks, or had allowed that folks could sign up for electronic notice of any particular project, so that they could understand what that project is and make an assessment with regard to whether or not there would be impact. We heard a concern that not everybody's checking their emails. Not everybody is really going to be looking at the electronic notice. And so this provision would allow any person to also request notice by regular mail, and would allow for or would require that they identify in the body what particular water district that they would like to receive notice either by regular mail or by email of where that water project is. So water districts are identified in statute, or it requires the state engineer's office to come up with water districts within each of the water divisions in the state. And so it identifies specific drainages with each one of those districts. And so the expectation would be, if we get a project application within that particular water district, somebody has signed up for notice either by email or by regular mail, that the state engineer's office would mail that notice of that particular project application to anybody who has signed up for it and provided a valid mailing address or email address. The last piece, and so the amendments to the existing subsection B, which would be a new subsection C, is simply meant to incorporate that mailing, the ability to have notice by regular mail. And then the last provision is a new subsection N. And as we were thinking through this, the subsection N specifically rates the Public Records Act. And there's a provision in the Public Records Act that requires that any custodian of public records in Wyoming that gets records through a voluntary governmental program, maintaining the confidentiality of those programs. This would exempt this program and these records from that provision of the Public Records Act. The reasoning being, if we're going to give somebody notice of what this project is, we need to be able to share the project details so they can make an assessment about whether or not it injures them. And so the state engineer's office, we felt that we wouldn't be able to give them proper notice unless we could provide the information with regard to the project, so other water users and individuals could make an assessment with regard to the injury. And so that that last proposed amendment would simply exempt this program and these project applications from that provision of the Public Records Act. Happy to answer any questions.
Questions, committee? Senator Pearson.
Thank you, Mr. Chairman. I have quite a few questions in this, and I want to be clear that it's not that I don't support this. Okay, when I was reading through, like probably some of the other people that had questions that had you propose this amendment, I have questions. So I just want to get clarification on a few things that concern me. So I'm wondering, my issue when we talk about conservation is, to me, that means that there's less groundwater. So I worry about what 5 years with no water on a certain piece of land, what kind of damage that's gonna do to aquifers. In the past 20 years with all of this drought, I mean, when I was young, there are springs that ran and ran and ran all the time, and now they're dry. So I'm just wondering how something like this, how you think that it would affect aquifers and groundwater with no water on these lands. I was also wondering, so if something like this is implemented, could voluntary somehow become mandated later? That concerns me. Then so I'm wondering, is this an either or proposal? So if a person applies, they can use none of their water. I mean, if someone applies for this program, they wouldn't even be able to, say, run a pivot across their land for, you know, a couple passes to keep water in the soil. I'm wondering about that. And then, of course, how it affects downstream users, but you kind of hit on that a little bit. I'm also wondering, so on page 6, where it's talking about the other owners, adjacent owners that may be injured in some way. So does there have to be written comments from others affected in order for their water to be restored? Like you said, some people don't get emails, some people don't check newspapers, things like that. And so I was wondering about that. Let's see what else. I was a little,
Excuse me, Senator Pierce, you want them to maybe take those
Yeah.
that you've asked right now, and then you can, so we don't get
sure.
too far down, they can keep those fresh on their mind. Is that okay, Senator Pierce?
That's fine.
Thank you. Yeah, go ahead. If you want to, maybe if you took notes on the first few questions she had and take it from there. Thank you.
So, Mr. Chairman, we may tag team this a little bit, but the first one is the aquifer recharge, I think was the question, and the potential for that. And that just, I believe it's going to be so dependent on the location and the geology in those areas. I get your concern. I just don't know that I have an answer sitting here today that it will or won't impact. And it, depending on what level of aquifer we're talking about, is it just the alluvium? So there's, I don't know that I have a good answer for that right off the bat, Chris.
We might as well just take them one at a time, Mr. Chairman, if that's
Yes, go
okay.
ahead.
Absolutely. And Senator Pearson, I think we've heard this concern from you before, and we've heard this concern from other water users in the area. Absolutely. Or folks in the basin. And especially with regard to the Upper Green, a lot of our wetlands areas are really created by irrigated ag. And we're really concerned in some of that shallow groundwater return flow water. And if you have a lot of just fallowing, what sort of impact is that going to have on the environment? And obviously we're very sensitive to that because we've heard concerns from folks out there. So a couple of things. That's one of the reasons why in here it allows the state engineer's office to condition these applications or condition approved projects to try and mitigate whatever those specific impacts might be because of a project. Because everything is going to be so place specific. It really depends on what's going on, just like the state engineer says. It's really going to depend on what's happening in the particular area where a project might be proposed. It may be that a particular project wouldn't have any significant impact on groundwater recharge or the shallow aquifer and the wetlands. But it would allow for the state engineer to develop rules and again, in a public process and working with the advisory committee and the stakeholders to try to figure out what might be considerations to try to rope all that in. And it's really difficult in a statute to try to capture all of that. And so the notion would be to try and figure out how to identify those considerations to mitigate those impacts. So that's one thing. Another thing would just be the density with regard to projects in a particular area. And I think depending upon what we might see as far as applications, one of those things that the state engineer will be able to consider for mitigation of those impacts if we have too much density in one particular area, so that there's not being kind of focused impact on any particular area. So we'd have to keep that in mind. Another thing to keep in mind is that all of these are temporary. So especially with regard to, except if you have a longer term irrigation system improvement, which this absolutely allows for. And actually, I think what we would actually prefer from the state engineer's office perspective is long-term irrigation system type improvements so that it's not just removing the water from the field and that's the only option you have. It's not an either or. But certainly these projects would be temporary in nature. And so any localized impact would also be temporary in nature. And that's one of the reasons why there's the provision in the bill that says if you have it for 2 or more consecutive years, you've got to put it back to the original use before you're eligible to apply again, so that we stay away from longer term single water rights participating and having that long-term kind of impact on a specific area. So definitely a legitimate concern. And those are the ways that we're trying to address that.
Go ahead, Senator Pierce.
Thank you, Chairman. So I understand that, but I'm saying while this project is in place, while this landowner is a part of this program, does he either have to not, he can't use any water? That's what I'm asking. While he's enrolled in this program, he cannot use any water.
So
Go ahead.
Mr. Chairman, that was one of your later questions. Happy to get to that one now. Not necessarily. No, in fact, I think, as I mentioned, the state engineer's office would prefer these long-term water system improvement type of projects, which would allow the water where, so say you're going to put a ditch and a pipe and you're going to do away with all the evaporative losses, the phreatophyte losses, the ditch losses, except for those that return back to the stream. You're going to make that conservation. So under that scenario, that particular water right holder would be able to continue to use the full measure of their water right and also have some conservation associated with it. We're obviously exploring now through studies different types of projects where it's just partial season, or it's a change in irrigation practices where they do their practices in a little different way to conserve some water. They're still able to use their water right, but it results in some conservation. And so we've tried to write it broad enough to capture any instance. And that's not even getting into system improvements for industry or municipalities like the city of Cheyenne and all the great work they're doing with regard to conservation. Is trying to allow for all of those things to come in. So it's not an on and off switch. You get to use your water or not use your water. It really depends. And we're trying to offer the broad a suite of potential options. If it results in conversation, we want it to be able to qualify.
And Mr. Chairman, I might just add that if somebody applies to the program, they don't necessarily have to apply all of their irrigated lands. They can apply for a project that is just a partial portion of their land, and that whatever the reduction in consumptive use is what we're talking about. But it can be just any component, multiple ideas of potential options, as Chris mentioned. But it is not, I'm signing up, I don't get to use any of my water right. The applicant will get to decide how he wants to participate in the program and to what scale. So they do have that option.
Thank you.
Thank you.
Senator Pearson, you have, did that answer the question so far?
Yep.
I just have one quick one. She hit on voluntary, and, you know, that's one part that I'm a little leery about here. When does it morph from, or could it morph from voluntary into encouraged mandated, government dictate on that? Could you comment on that?
Absolutely, Mr. Chairman, and I'll take that. So my short answer is no. The whole reason why the state engineer's office put this forward is to avoid a scenario where we might have a situation where mandatory reductions are required. The state engineer's office is a state agency. It's only allowed to take that kind of an action if it's authorized to take that kind of an action. And so it's either that it was with regard to involuntary reductions. So it's either the typical priority regulation, which the state engineer's office engages in every single year to satisfy senior rights, or in this situation, what we're trying to address is mandatory type of regulation in order to satisfy our compact obligations, which are a Wyoming state statute as well. And so the whole point of this is to try to figure out a resolution to the dispute we have with our friends downstream with regard to differing interpretations on what does that obligation mean. And if you ask some of our friends downstream, they would say, you need to shut off right now. You need to engage in your authority under the interstate compacts, and you need to go turn off your water users. We disagree. We don't think the compacts in the current conditions that we're in require that action. And so what we're proposing is something to try to avoid that involuntary type of reduction. And so in the future, the only way that that type of involuntary reduction is going to happen is, one, it's necessary to satisfy our interstate obligations under those compacts, which are Wyoming law, which direct the state engineer to comply with that law. Or a court decides that we must in order to comply with that law. That's how this turns into involuntary.
Thank you. Senator Pearson, you have further questions?
Yes, Mr. Chairman.
Go ahead.
So another one was on the written comments from adjacent landowners. So, well, this can be two-part, but it's in two different sections of this. So on the written comments, say an adjacent landowner does not reply or doesn't even know this is happening within 30 days. And then is there a way to make sure that their water is not affected? And then another one would be, say a year into this, and the adjacent landowner is really realizing the impacts of what his or her neighbor has done. I know that there's a way for them to go to the courts and that, but I would like to know, do they have a way of voicing their opinion and possibly restoring their water? And then if they do go to the courts and do some sort of an appeal, or I can't remember what the word was in there, but who pays for that? Who pays for those court costs?
Go
So,
ahead.
Mr. Chairman, so first, the appeal provisions that are in the draft bill do not require somebody make a comment in order to engage in an appeal, order to bring an appeal. So the first question I think you're asking, Senator, was if somebody doesn't comment, do they still get to defend their rights? And so there's no tie in the bill that requires somebody to make a comment. If they're injured by or would be injured by a project, they could still appeal. That appeal, as it's drafted here, is to the Board of Control. And so that's how we see other typical appeals happen if you're in a situation like a permanent change. If somebody wants to do a change of use or a change of place of use, then somebody who feels like they might be injured by whatever that petition is can lodge an objection. It goes through a contested case trial type hearing in front of the Board of Control. It's an administrative process, hopefully quicker and less expensive than a complete judicial process. You go through that process, the Board of Control then makes a decision with regard to that appeal on whatever basis the appeal is brought, the assertion that whatever that project is harms my water right in some way. The Board of Control then makes a decision, and then that can be appealed to the Wyoming District Court. And so that relates to Wyoming water right holders whose water right might be injured. Anybody else who thinks that they might be negatively impacted or adversely affected by a project already has the right, and it's just repeated in this statute, to bring something under the Administrative Procedure Act to a Wyoming District Court. This statute, or this bill draft, just like every other Wyoming water statute, that cost would be borne by whoever's bringing the objection. To prosecute whatever they believe their objection is, they would have to bear the cost with regard to that objection. That's just like every other water right provision that we have that allows for an appeal.
Mr. Chairman, I might just add one clarifying
Yeah,
thing.
go
I
ahead,
don't
Mr.
know if
Whitman.
it's confusion or not, but if somebody chooses to participate in this, it is not necessarily a 5-year signing period. It's an annual, or even there are times when you can do it for part of a year. But the applicant gets to choose how long he wants to participate. He doesn't just sign up and it's an automatic 5 years. That applicant gets to decide how long he wants to perform this project or this activity under this program.
Thank you. Follow up, Senator Pearson. Further,
Thank you, Mr. Chair.
yes.
I'm sorry, I just have a lot of questions. So on page 7, letter E. I just have issue with some of that wording and how that would affect downstream users, or, when it says, if an approved conservation project is located on a source of supply that is being regulated by the Water Commissioner under WS 413606, the Water Commissioner may prevent head gates of all downstream diversions that are subject to the regulation from that source of supply from diverting and using any water. So when I see something like that, it just puts red flags in my head. And so, that possibly this could affect downstream users or other people that are using this water if the commissioner is able to come in and shut off head gates that are supporting adjacent lands. And so I wanted you to address that one too.
Go ahead, Mr. Brown.
Mr. Chairman, Senator Pearson, so in my view, the most operative provision of subsection E is that first sentence, which is a water commissioner is not going to be able to regulate a stream for the purpose of shepherding the conserved water. And shepherding is just generally taking it or through administrative regulation, the water commissioner would take it from the place that it's created to the place that you're delivering, Fontenelle, for example. And so it just would prevent other water users from picking up just that conserved water. So that first portion, that first sentence in the statute says, no, this bill is not granting that authority. However, in this very limited exception to that general rule in the first sentence, is that if a stream is already under regulation, so it's already under priority regulation. So some senior water user on a stream, and there's multiple streams in our portion of the Colorado River Basin that are under regulation every single year. And so that the main issue that we were seeing with regard to asking for complete shepherding authority is that it was going to harm folks that rely on either Free River or seconds. Because in order to shepherd water, you've got to cut folks back to precisely the amount of water that they're entitled to under their water right. And so while that's not going to necessarily, at least with regard to Free River, going to be an injury to their water right, because you don't have a water right to Free River, it's going to cause some impact to them. They've come to rely on that Free River. And so that's why we haven't asked for general shepherding in this legislation. But if the stream is already under regulation, so folks are already being reduced to the amount of water that they are lawfully entitled to take under their water right, the second provision would simply allow the water commissioner to not allow somebody to divert that additional conserved water. So that portion that you were concerned about, Senator Pearson, that says diverting and using any water if you continue on to the next page, conserved by the conservation project. So the only water that a commissioner could disallow the diversion of was the additional water that was conserved under the project. So downstream users would still be lawfully entitled to divert the total amount of the natural flow that was existing in the stream and just not divert the conserved water. So this is an attempt to try to figure out how might you do this if we end up going in this direction in the future under these streams, how might you administratively get that done? So it's a very limited exception to the general rule is there will be no shepherding of the conserved water.
Thank you.
Okay, are those all your questions, Senator Pearson? If just, we've got what, about an hour, so keep, not to cut anybody off, but kind of want to get through this bill here. Probably have more people that want to testify, so, and I'm not, you, all good questions. Yep.
Thank you, Mr. Chairman, but honestly, public, he is trying to cut me off. No, I don't have any more questions. Thank you.
Any further questions for the state engineer and Mr. Brown? Thank you, gentlemen. Others in the crowd that want to testify here on this? Senator Larson. Let her rip.
Mr. Chairman and committee members, I'm sorry I wasn't here at the start of this to help present it, but I'm on the select water. I'm on the Upper Colorado River Task Force and that. So I've been watching the bill. I should have read it last night, but I'm for it. I think we need to do something to give the other states notice that we are trying to conserve water, and hopefully we won't go to court, I think is the main reason why we're bringing this.
Okay. Questions for Senator Larson? Sorry, I should have had you introduce yourself, but I guess go ahead. Just keep it formal.
Mr.
Yeah.
Chairman, sorry, Senator Dan Larson. Thanks.
Thank you, Dan. Senator Larson, no questions for, thank you, sir. Appreciate it. Further testimony here. Go ahead and introduce yourself and tell us who you're with, and we'll keep her rolling.
Good morning, Mr. Chairman, members of the committee. I'm Travis Deta. I'm the Executive Director of the Wyoming Mining Association. In support of the bill, I'm joined by Mrs. Jody Levin, who represents our Trona producers, and Mr. Craig Rude with We Soda out of Green River. Just a quick snapshot of your Trona industry. Our Trona industry, we mine about 16 million tons of Trona annually in Wyoming. The industry pays a little bit more than $200 million annually in taxes and royalties, a payroll of about $450 million for a total industry value average of $652 million. Our Trona and our soda ash from our Trona resource is our top international export. The industry employs roughly 2,300 people directly and about another 900 contractors. And so it's a very, very important part of our state's economy and a tremendous economic driver for Sweetwater County. And this issue, the water issue, is very important to our producers. And with that, again, I would reiterate the industry support of the bill and turn it over to my colleagues to kind of discuss it a little bit more.
Thank you. Go ahead.
Good morning, Mr. Chairman, members of the committee. I'm Jody Levin. I'm here on behalf of the Trona industry. As Mr. Deta just outlined, the Trona industry, as you all know, it exists only in one county in Southwest Wyoming. It's a pretty special resource. We also understand water is a special resource. I grew up in agriculture, and here we are, Senate Ag Committee. There's going to be a lot of questions and concerns when it comes to water. We respect that. The industry needs some tools. We need something to do to go forward to show, as Senator Larson said, that the upper basin to all the states, but that Wyoming is serious about trying to find a solution for the Colorado River. Just to put it quite simply, and then I'll hand this over to Mr. Rude so he can give you the operator's perspective on this. If we don't have water, we don't have a soda ash industry. So we have 2,300 employees at risk in Southwest Wyoming if we don't find a solution. The only solution right now, if there was a curtailment on the river, your Trona producers are going to have to look to buy a ranch and dry it. They don't want to do that. That's the worst thing for agriculture. That's terrible for our communities. That's terrible for Wyoming. So we encourage you to pass this forward, give us a tool in the toolbox as we work to try to find some solutions, and hopefully Mother Nature starts to cooperate and we get some snow. Thank you, Mr. Chairman.
Thank you. Questions, committee? Go ahead, sir.
Good morning,
Thank you.
Mr. Chairman, Senators. My name is Craig Root. I work for WE Soda. I do government affairs for them, but I've been in the industry for 34 years and done a little bit of everything in the industry. And it is snowing in Sweetwater County this morning, so that's a good thing. But we are in support of this bill, as my colleagues mentioned. We need some tools in the toolbox to keep the water in Wyoming. And when you combine this with the Fontenelle storage and insurance essentially that you can buy there, that gives us a couple of tools to at least keep the water in Wyoming and maybe run for another year if this drought keeps getting worse. You know, we in the industry know that the only two basic ingredients we use to make soda ash is Trona and water. So there's a lot of stuff in the middle, but those are the only two ingredients. So water's very important to us, and we're continually working for ways to conserve. Right now, we've done estimates and we reuse, or recycles the buzzword, but reuse the water 12 times before it evaporates. And that's from the time we take it out of the river till the time it evaporates. So we've been doing things over the years to reduce that. And since I started in the industry, we've reduced our water usage in over half. So we've done some big things to do that. And I think this conservation bill just gives us another tool to hopefully keep some water in Wyoming and get us one more year till it snows. One other thing we have going on is we're doing the first solution mine in Wyoming in a new part of the ore body that can't be conventionally mined, and we're doing the planning for that right now. And obviously water's a key component of that. And we need some certainty around that. If there is ever certainty around water, we need as much as we can get. So this gives us a tool. Is it the fix all? No, but it gives us a tool to help with that. So
Thank you.
thanks.
Committee, questions? Just a real quick one. With supply and demand, tell me the difference or how to weigh conservation of the water versus price. I mean, especially in the mining industry, is it always available if you're willing to pay more money for it? Thank you.
Mr. Chairman, I mean, so far it has been, but I think we're reaching the point of critical mass. And I mean, I think water is going to be a huge commodity going forward. But so far it's always been available.
Okay. Thank you. Thank you all
Thank you,
for your
Mr. Chairman.
testimony. You bet. Others from the gallery here that would like to speak on Senate File 84. Go ahead.
Mr. Chairman, members of the committee, Kelly Carpenter, Wyoming Farm Bureau Federation. Sitting in support of this bill, maintaining water for agricultural purposes is a top priority for our members. We think this bill would accomplish that long term. We appreciate that the pilot program is voluntary and not a mandate, and we would urge it to stay that way. This program would be a tool in the toolbox, as we've been hearing, to keep the conflict that may further limit agricultural water use in the basin out of the courts. We support the amendments from the state engineer's office regarding notice. There's not ever an ideal way to communicate with everyone, but the amendments get pretty darn close. Also, as a trade organization with a wide-reaching publication, we'd be happy to be a part of those efforts to help efficiently notice those that might be impacted. With that, I'll take any questions. Thanks.
Thank you, ma'am. Questions, committee? Seeing none, go ahead.
Mr. Chairman, Keith Kennedy on behalf of the Wyoming Association of Irrigation Districts. You do have a letter in front of you, and the the one thing that I would point out beyond the testimony that you were just offered is the support of one of the irrigation districts that is within the basin. The Eden Valley Irrigation District supports this. And as someone who has been an irrigator for a large portion of their life, to one of the questions that was offered earlier, I would much rather deal with 10 or 15% less water over the season because I have voluntarily conserved that in some manner rather than to be regulated and not have any water. And so we look at this as something that, while it's not desirable, it's easier to deal with than the loss of water. And with that, I'd welcome your questions.
Thank you, Mr. Kennedy. Questions, committee? It's all yours, Mr. McGagna.
Thank you, Mr. Chairman. Jim McGagnon with the Wyoming Stockgrowers Association. I would love to be able to sit here and tell you that this is totally unnecessary. Unfortunately, the scenario we're facing in the Colorado River today is that we do believe that the state needs to show some good faith in attempting to address some of those water issues there, because it's been interesting to me. Our governor traveled back and met with other governors in DC and gave a somewhat favorable report. And the day after that, the state engineer in Arizona announced that they're willing to go to court and fight to the death to get the water they think they're entitled to out of the upper basin. So I think a good faith show by Wyoming is important. I apologize, I came in a little late. I presume that the state engineer or the Attorney General's office presented their amendment to you. We
Yes, sir.
worked with them on that amendment, and we feel that that does address one of our primary concerns with the bill, which had been proper notice to those who potentially could be impacted. The other thing that I would really emphasize, I think is important in this bill, I'm not naive enough to think that we've got it perfect the first try on such a novel concept. So the fact that the bill requires that the state engineer report annually back to the Select Water Committee, I believe it is, or perhaps it's the Ag Committee, I don't recall that. But anyway, is critically important so that the legislature can trace what's happening and make adjustments if deemed necessary, or discontinue the program if it turns out to not be working appropriately. But with those constraints, because of the need that exists today, we, with some reluctance, nevertheless, encourage you to adopt the amendments been proposed and move the bill forward. Thank you, Mr. Chairman.
Yes, thank you, Mr. McGagnon. Questions, committee? Go ahead, sir.
Mr. Chairman, members of the committee, I'm Jack Berger from Saratoga, rancher there. I got a little different take on things, some concerns. Senator Pearson, you asked some very good questions. I mean, that's glad to see that knowledge and the kind of the unforeseen negative things that this can bring and stuff. You did a very good job, and leads right into what I wanted to talk about. And that, and I don't need to go through the bill. You've already, how many times injury is mentioned. Can be no injury, no. You need to understand that really injury doesn't mean anything in the state anymore. It's, I don't know, it could be proven or prosecuted or anything. And I mean, each one of these bills, you know, like the Sinclair exchange, injury is supposed to be black and white right here. Bills like Sinclair, Banks gray area bills, what was the other one? That Senate File 43 last year on temporary water agreements, made more gray area there. See, this is what we're doing to injury. And to think there's any security in that, and I'm going to have to give you a personal example. In October of 24, sent a letter to the state engineer. I've already talked to Brandon that I was going to bring this up. October of 24, sent a letter, my attorney did. And accompanying my letter was a letter from every other person on my creek about a reservoir that fills out a priority and stuff. And anyway, I was trying to address that. I hadn't heard anything, you know, in 2 or 3 months. I got the governor's office involved. Still going into the last irrigation season. I hadn't gotten any response. And then the type of year we had last year, what I was worried about was on steroids and stuff. So my attorney finally said, let's challenge them to come for a on the ground visit. So we did that. And finally in August, 10 months after I wrote the letter, we got Chris Brown, Brandon Gephardt, division superintendent, all my local guys stuff. And I had 150 acres completely dry. Now, to me, that's injury. While this junior reservoir had filled. And I brought them all there, showed them the 150 acres. I took them up the creek. We sat on a ridge, showed how the whole system worked and stuff and what this reservoir was doing to us. And I got absolutely no answer. And what are we, 6 months out now from August? Still nothing. So we need to understand that what has been done to injury and that there's no security in that. And there's definitely going to be some negative impacts to this. And I don't know, what the answer is and stuff like that, but it's a real concern, I think, for, neighboring ranches, whether you're on the Colorado side or in the rest of the state.
Mhm.
So anyway, that's what I wanted to bring up, and I'll stand for any questions if there's any.
Thank you, Mr. Berger. Committee, Senator Craigo.
Thank you, Mr. Chairman. Thanks for being here, Jack. Appreciate it. You always show up at these and I super appreciate the insight you bring. As we're talking about this particular concept, and I understand you have a bigger issue about injury, and you and I have talked extensively about that, and that might be something we have to look at on a different day. As far as the concept of this bill, though, what do you think about the concept of the voluntary conservation and how that would apply? And disregarding the injury issue, if we can deal with that, what do you think about the program itself?
Well, I think the conservation word is, I don't see any conservation to it. You're changing the timing, the moving of the water, but I mean, whether you put it on the land and it comes back as return flow and stuff. I mean, to me, I don't see conservation in it. I just see, and I mean, maybe the optics of it to the downstream users, maybe that's worthwhile, but to me, I don't really see conservation to it.
Follow up? Further questions? Committee? Yeah, thank you for being here, Mr. Berger. It's always good to hear both sides of the legislation to weigh the pros and the cons. So appreciate your time and effort to come here. Others?
Good morning, Mr. Chair.
Yeah, go
My name is
ahead.
Brad Brooks. I'm the Director for the City of Cheyenne Board of Public Utilities. Good to see you all again. I also serve on the Governor's Advisory Committee for the Colorado River, representing municipalities. I just want to share with you, as has been mentioned earlier, this bill has been in the works for a long time. The State Engineer's Office, the AG's office has done a really great job, I believe, in putting this together, listening to concerns not only of our committee, but also of people around the state. As has been mentioned, I'll use the same wording. This is another, and I like that was brought up because that's what I was thinking of sharing. It's a tool in the toolbox. And when I look at today in water, and let me tell you, when I see the weather that we're facing today, be out this weekend working in short sleeve, it's not good. So it has me concerned and worried. And so any more bills or things we can do legislation wise to provide some conservation measures where we can maybe possibly bank or put some water away for a rainy day when we need it. It just adds more. The word I like, I think that Chris Brown was talking with me earlier, is flexibility. It gives us flexibility, and we need flexibility. Wyoming water law is very strict. It's very rigid, and it's rigid and strict for a reason, because water is very, very valuable. And I think anything we can do with the example of this bill is providing more flexibility for water users and options in these type of situations, I think is very, very valuable. So I just ask that you'd consider that. The other thing, in reading a lot of the documents for Colorado River, the Bureau has out their draft EIS right now on the post-2026 guidelines. When you look through that and say there is an agreement that is not made and they step in, I'm just telling you already what's starting to be formed. In every one of those, with the exception of no action, there's one of the plans is no action, leave it alone. They all include some form of conservation. And the numbers I read were anywhere from 2 to 400,000 acre feet from the upper basin states. Now, who knows how that'll be split up, but that tells me that we're going to have something on the books ready to go. And I feel that this bill sets us up and provides us with that opportunity. So whether we like it or not, I think we do have some form of cutbacks that we're going to experience from the Colorado River, and Cheyenne as a municipality gets 70% of our water from the Colorado River. So when I have to look at options of how I'm going to get water to Cheyenne, if somebody comes and tells me that, hey, you're not going to be able to divert that 70%, that's a huge amount of water. And so I think providing flexibility like this with other legislation is just a great opportunity for us to handle these unique situations. So I appreciate your support. I'm in full support. I would add also our advisory committee is in support of this bill as well. So be happy to answer any questions you have. Again, thank you for your time and considering this.
Thank you, Mr. Brooks. Questions? Committee?
Thank you.
Okay, thank you. Others? Going once, going twice. We'll close public. Oh, we've got some online. Thank you, Clayton, for the nod there. Go ahead and bring them on.
Raftopoulos.
Who do you have?
George Raftopoulos is in the lobby.
Okay. Mr. Raftopoulos.
Yeah, it's a tough one. Yes, thank you, Chairman and Senator. Thank you for taking the time. I am a rancher on the Little Snake River Valley, a different basin, but come in here and to speak in as a proponent of this bill. My experience was only with the SCPP, and I thought it went kind of pretty well for our operation. I'd just like to reiterate, I think the flexibility in it is what we really like to see. You can really change this program around a lot. It adds a lot of economic benefit, I think, even to the communities, and it gives a monetary value to the water. This bill doesn't have to be perfect because I think there's some market action at work here with the fact of what's that water really worth to produce the crop or the commodity as in regard into what's it worth to the Trona mine or to these downtown users. I think that's a really cool concept to get going, even though it's not perfection. And at the same time, it protects these water rights, which are property rights. And I think from what I've heard, and I'm not the most versed, but from what I've heard, the bill was wrote with protection of property rights kind of at least in mind, and water rights in mind. So I think it gives ranchers, property owners, and farmers flexibility and an ability to monetize this water asset, which we all know is really important. We also know there's probably going to have to be some sort of solution coming down the pipe. And so to go for perfection when pretty good is probably a good start. I don't want to miss the forest for the trees, and making sure we get out ahead of some of this stuff to protect these rights, because definitely in the lower Little Snake River Valley, the water is a big asset to the ground. Definitely upgrades the ground. So in closing, I know there's probably some problems within a program, like they're all in any kind of program, but we see just mainly benefits out of this program. And one thing to touch on is that injury seems to be a key word in some of these, and I don't know all the right answers, but I mean, I don't know what this program does that's any different than what, like, a lot of these conservation programs have pushed pivots and alternative irrigation, and we see quite a few problems from there, even in injury to neighbors from return flow and stuff when it comes out of the dam irrigation and flood irrigation into an alternative irrigation. So I don't think that's as relevant as maybe a lot of other people do, and I could be wrong, but like I said, definitely like the bill and like where it's headed, and I think it's well thought out. And thank you for having me, Chairman and Senators.
Thank you, Mr. Raptopoulos, if I said that right again, but.
Yeah, you did. Good work.
Committee questions. Thank you for your testimony, sir. Appreciate
Thank
it.
you.
Others online.
One more, it's, Jeb Stewart.
Okay. Mr. Stewart, if you're there, you're on. Calling Mr. Stewart.
Oh, here I am. I'm here, Mr. Chairman. Can you
Go
hear
ahead
me?
and introduce yourself and tell us where you're from.
Thank you, Mr. Chairman. This is former Representative Jeb Stewart from House District 47, submitting some comments on behalf of myself and other residents of House District 47. And I'm so happy to be here, Mr. Chairman and committee. You have my detailed comments. I emailed you last week. Today, now I would just like to highlight some of the main points from the detailed comments I sent you last week. Mr. Chairman, even though Senate File 84 states that a voluntary water conservation program reduces consumptive use, there will be no reduction in consumptive use in Wyoming's Colorado River Basin as a result of this legislation. Only a delay in the timing of consumptive use. Mr. Chairman, there seems to be a lack of clarity and definition of the term conserved water, which there have been some attempts today to narrow that down, which is clearly lacking in the legislation. I feel this could have some unintended consequences in the future, Mr. Chairman. Mr. Chairman, a moment on paragraph e. Contrary to the intent of this legislation to disallow shepherding of water, shepherding of foregone irrigation water will occur in order to properly account for it to be stored in any reservoir contemplated to store conserved water. Many other Wyoming water right diversions will face regulation in the past where there was none, with the end result, the loss of Free River. This is injury, Mr. Chairman. Further, when conserved water is released from storage out of a reservoir, it will be shepherded to be delivered to a junior right automatically by existing statute. And I would just make note that existing statute is 41.3.304. This gives the water commissioner authority to take over the stream and shepherd water when released water uses the bed of a stream. Many other Wyoming water diversions will face regulation when water is released from any reservoir this conserved water will be stored in, with the resultant loss of Free River and injury. So, Mr. Chairman, I would stand for questions at this point. Before I close, I'd like to thank you again. I'm so happy to be here. And I would encourage your no vote on this bill. Thank you.
Thank you, Mr. Stewart. Committee, any questions for the former representative? Thank you for your testimony, Mr. Stewart. Others online? So we're done online now too. I guess we'll close public testimony and work the bill. Committee, what do you want to do?
Move the bill.
Is there a second?
I'll second.
Been moved by Senator Crago, seconded by Senator Pearson. Discussion.
Do we want to make the amendment? So I'm going to offer an amendment here as presented by the SEO's office. So on section B, we're going to add in a new beginning to section B for the purpose of providing notice of the program and conservation project applications to water right owners and other intended persons. The state engineer shall, 1, within 90 days of the effective date of this act, cause to be published in at least 3 newspaper published within Wyoming's portion of the Colorado River Basin once a week for 3 consecutive weeks, a notice of the program and how water right owners and other intended persons can obtain program information. 2, within 90 days of the effective date of this act, cause to be published in at least 2 Wyoming trade publications related to the irrigation agricultural water use sector, a notice of the program and how water right owners and other interested persons can obtain program information. 3, within 120 days of the effective date of this act, hold at least 3 public meetings at different locations within Wyoming's portion of the Colorado River Basin that provide notice of the program and how water rights owners and other interested persons can obtain program information. And 4, as part of the notice required in subsection B1 through B3 of this section, and as long as the program under this act is authorized, provide water right owners and other intended persons the ability to request notice of conservation project applications by regular mail or electronic means. Any person requesting notice of conservation project application shall identify the water districts for which their request applies and shall provide a valid mailing or email address. And then we're going to move on to the existing, I guess, we're going to amend then the existing section B to C, and I think this might cause us to so there's already a C, so this is going to shift everything down. So sequentially, numerically, it's going to shift all of the numbers in this section then down.
And excuse me, Senator Love, if you
Yes.
don't mind. I think it's just in the essence of time, you can just, like you said, move it down to C and then just put the amendments that are in red on this so we don't.
Yep.
Is that good with you?
Yep, so we're
Thank you,
gonna
sir.
letter this as C now. As we go through, we're going to page 5, line 8, and after the word provide the, add regular mail or electronic notice. Then on line of 7, we're going to strike electronic and just leave provide notice of. On line 12, we're going to, after the word application, we're gonna add within a water district to all persons. And then on line 13, we're going to strike electronic and leave notice of, and add in of applications within that water district. Continuing on, notice and have provided a valid, and we're going to insert mailing or email address to finish that line.
Discussion committee on the amendment. I guess, has it been moved?
I move that amendment.
Is there a second? Moved by Senator Love, seconded by Senator Crago. Discussion on the amendment. Clayton,
Mr. Chairman, I just wanted to confirm, are you also moving the second page or just the first page?
So on the second page, we have another one that is section N, page 12, line 8. Does that need to be a separate amendment or can we do it all?
I think we could add that, committee, just make it all one amendment. Go ahead, Senator Crago.
Mr. Chairman, we can do that. We just need, there's one typo in that amendment. So on the second line of that amendment, it says shall not, and I think it should say shall not be subject to. But other than that, I think it's fine.
Okay. Is that good with you, Senator Love, to put them together?
So amended, friendly amendment.
Yeah. Okay. Discussion. Committee. Do we need to roll call vote this? No. All those in favor of Senator Love's amendment, say aye. Aye. Opposed? Motion passes for Senator Love's amendment. Other discussion, other amendments, committee, Senator Crago.
Mr. Chairman, I was going to move the other amendment brought to us by the state engineer's office, which is the definitions regarding curtailment and involuntary water use regulation. I believe Clayton has that. I would move that.
Been moved by Senator Crago. Is there a second?
Second.
Second by Senator, can't remember where you're from. Where are you from? I'm just teasing you. Senator McEwen.
Question.
Question's been called. All those in favor of Senator Crago's amendment, say aye.
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 Opposed? Motion passes. Committee. Discussion on the bill. Go ahead, Senator Pearson.
Thank you, Mr. Chairman. So in section 6, where it says the state engineer shall file a report with the Select Water Committee, I would also ask that there be a report filed with the Ag Committee. I don't know if there's a way to do that, but as in many things in this legislative session, there are committees that feel like things should be on both sides. So I don't know if it's possible to add a friendly amendment there.
Yeah, I think it would be appropriate, probably. And I don't know. Okay, thank you, Senator. Been moved by Senator Pearson, seconded by Senator Crago to add language to the bill that the report would come annually as well to the Ag Committee along with the Select Water. Did I say that right? Thank you. Go ahead. I think that's good because Select Water is kind of interim and we're here during the session too, so it's probably a good time. Discussion. All those in favor of Senator Pearson's amendment, say aye.
Aye.
Opposed? Motion passes. Let's keep going here. Any other amendments to the bill?
Question.
Okay, we'll go ahead. Somebody want to, I guess we've moved the bill. And any further discussion on the bill? Senator Pearson.
Thank you, Mr. Chairman. I'm going to vote for this bill to get it to the floor. Because I think that everybody has needs to have the opportunity to kind of hear and discuss what's going on here. I fully support our industry in Sweetwater County. But but I also fully support our ag producers, and I know that something needs to be done. So I am going to vote yes on this to get it to the floor. Because I think that it's worth the discussion, and we really do need to be thinking about these issues, but I just want Trona and ag to both know that the reason that I brought up the questions that I did is because I support both. So, thank you.
Committee, further discussion?
Question.
Question's been called. Roll call. Clayton?
This
Go
is a
ahead.
roll call vote for Senate File 84 as amended. Senator Craigo,
Aye.
Senator Love,
Aye.
Senator McEwen,
Aye.
Senator Pearson,
Aye.
Chairman Ide.
Aye.
Mr. Chairman, that is 5 ayes.
Okay. Thanks, everybody that testified today on this bill. We're going to move on to Senate File 50. Senator Love, do you want to introduce your bill?
Absolutely. Mr. Chairman, through you. So State Engineer Surface and Groundwater Study, Senate File 50, an act relating to water requiring the state engineer to conduct a groundwater study and control areas as specified, requiring reports, providing an appropriation, and providing for an effective date. So this bill comes out of a necessity brought by controls that were put in place by a previous study just over 10 years ago. At the time, it was suggested but not mandated in the bill that additional studies be performed as we move through time on a 5 to 10 year basis. We've now exceeded both of those recommendations. And so we're coming back without mandate, but looking for the opportunity to study more water in these control areas. There are a number of them around the state. We're sitting currently in one. Starting on the western side of our county here, all the way through the eastern end of the county, we've gone to minimum acre spacings for wells. Some of them are as large as 10 and 20 and 40 acre spacings for wells. We have the western side of the county right now. Surface water's completely dried up on some of our bigger ranches. I know some of the home wells have dried up. And so I think it's incumbent upon us to go ahead and study this and give the state engineer's office the financing to get it done so that they can move forward successfully and we can have a better management plan. It's also currently under what controls exist. It's really limiting in development, and it's put a moratorium on all agriculture irrigation wells. So that's the purpose for this bill.
Thank you, Senator Love. Anybody from the gallery that would like to talk on this bill? Go ahead, sir.
Mr. Chairman, Brandon Gebhardt, State Engineer. We've had the opportunity to work with Senator Love amongst some other legislators to discuss this, support the bill and the idea. We did work more recently with Senator Love on maybe a proposed amendment to address some of our concerns, and I can certainly go through that. I might have somebody pass out this amendment and fill out the form, but
Yeah, go ahead if you can get that to us here.
you bet.
Go ahead, Mr. Gebhardt.
Thank you, Mr. Chairman. So I'll just step through it and it's describe what's in our proposal. But page 1, lines 10 and 11, delete for recommended residential lot sizes and insert to assess corrective controls within groundwater control areas. This suggests that the study assess the status of the aquifer after the period of time that the order has been in place. The title suggests that the SEO make a determination on county lot sizes. We have concerns that this may overstep county authorities that are derived in Title 18 for subdivisions. So the way I think about this is providing them the best information possible through this reanalysis to allow them to make appropriate decisions with good information. That's how we're looking at this study. On page 1, line 13, before not, insert subject to available funding. The reason for this is the appropriation for the bill is one-time funding, while the bill requires study every 10 years. So it's difficult to predict what funding may be required in the future. We're hopeful that it would be minimal, but we don't know at this point right now. So whatever that funding is required in the future, we might need future appropriations. Without that, we would not be able to comply with the statute. So this suggestion helps address that concern. Page 2, line 2, after Wyoming Statute 41-3-912, insert, and where the state engineer has ordered one or more corrective controls under Wyoming Statute 41-3-915. It's our understanding that the primary concern of the sponsor was to assess the Laramie County control area. This line limits the current mandatory review to just the Laramie County control area. Page 2, line 2 through 4, delete. Determine water consumption based on the total area and controls that may be necessary to provide for the, and insert, assess the effect of the ordered corrective controls, including assessing. So the language of the bill indicates that the SEO will determine what controls are necessary for recharge of the aquifer. Does that mean that the recharge to put the aquifer back to its natural state, to maintain the aquifer's current levels, or to allow for some amount of drawdown? If any additional withdrawals are allowed, then there will likely be some additional drawdown because current withdrawals already exceed the amount of natural recharge. The proposed language provides for the assessment of the rate of withdrawals compared to the recharge, but it does not require halting any declining aquifer levels. The next suggestion on page 2, line 5 is just replacing underground water system due with aquifer compared. Aquifer is kind of the standard language in statute. Page 2, line 5, after consumption, insert from that aquifer. That's just a clarifying remark. Page 2, line 6, inserting the word modeling to the statute. Page 2, line 7, delete test and replace it with monitoring. In our world, a test well is simply an exploratory well. What we were envisioning would require a water right for monitoring. Page 2, line 13, we're suggesting just a little additional time from 15 to 60 days from once the study is completed to do a presentation to the committee. And then on the rest of these deal with time and money. We sketched out a schedule of how long this would take. We believe this is probably a 2-year study. Once the bill becomes law, starting in July, we have about 7 or 8 months of procurement, which would include scope development that we would send to the contractors. We'd have to develop that scope. I would feel more comfortable too coming to an interim committee with this committee to explain the scope that we've developed, just to make sure that we're all on the same page before we go out to bid for contractors. And then with the 2-year study starting in the winter to spring of 2027, that puts a finish date of winter to spring in 2029 with a June completion date of of 2029. That puts it close. I typically like to allow a little extra time, particularly when the study is in statute, because it's easier to finish early than it is to come back to this body to amend a date. We did some analysis on the cost, and we have had some conversations with the sponsor. We believe that 500,000 is probably more appropriate for this level of study, for a 2-year study. And then the last two proposals are just the reversion date of the appropriation, and that's just allowing an extra year from when the study is completed for the same purposes, is not having to come back. If we have change orders or if we're closing out the project and we're nearing that timeline, just allows us time to make sure that we can get everything closed out and not have to come back for an extension to this body.
Thank you, Mr. Gebhardt. Is that it?
Mr. Chairman, that is it.
Thank you. Discussion on the amendment. Senator Craigo.
Thank you, Mr. Chairman. So on page 2, line 2 through 4, where you're suggesting we delete determine water consumption based on the total area and controls that may be necessary to provide for and then strike that and insert assess the effect of the ordered corrective controls, including assessing. And it looks to me like we're shifting the goal of the bill as from looking forward to looking backwards, but explain to me if I'm wrong about that. I mean, I think that as I read the bill, the intent is to help us plan going forward, not to determine what the effects of our previous actions or your previous actions have been. So if I'm wrong, just clear that up for me. Thank you.
Mr. Chairman, Senator Craigo, I think it's probably a little bit of both. The tool we hope to gain out of this is the modeling and the information so that we can make estimates about going forward, but we also are interested in knowing, are what we have done so far working and how well, and do we need to do more or do less once we know how that has affected the aquifer? Does that help answer your question? Not really.
Go ahead, Senator Craigo.
Thank you, Mr. Chairman. So do we need to clean that language up a little bit to make it clear we're doing both? Because as I read it, we're only looking backwards now. I'm happy to do both. And if we need additional funds to do that, or if that's why we're asking for additional funds, fine. I just want to make clear that we're not only looking back, that we're also looking forward, and that the counties can use this for planning purposes.
Mr. Chairman, Senator Craigo, I would be fine with, and I don't know how to do it as I'm sitting here, but I would be fine making sure that we are providing the tools to help the future planning.
Senator Craigo.
Mr. Chairman, we have a really good lawyer sitting behind you, and I bet we can figure it out. I mean, we may not today, but on the floor, I'm definitely willing to help. I just don't know if I like that particular language.
Mr. Chairman, Senator Craigo, if you're okay with it, we will certainly work on something and we can get it to Senator Love as the sponsor and yourself and see what you think of it.
Thank you.
Thank you. Any other questions? Thank you, Mr. Gebhardt.
Thank you.
Further testimony. Just FYI, while everybody's sitting down, we have about, 10, 15 minutes. We need to get out of here by about 5 till 10. So much as time as you can, but keep it direct. Thank you.
Morning, Mr. Chairman, members of the committee. Troy Thompson, Laramie County Commissioner. You should have received an email this morning from our chairman of Laramie County Commission stating our apologies for not being able to be here. Luckily, we got things changed around, so I could be here. Speaking in support of the bill, for the Wyoming County Commissioner Association, as well as for the Laramie County Commission. And a little bit of history with this. I took office about 15 years ago, and multiple times we reached out to the state engineer at the time asking, hey, listen, we need some guidance here. I mean, we are not water experts on the commission. We need some help. And there was a memo that had come out from the state engineer's office that said, maybe a minimum lot size of 7 to 8 acres would be appropriate, but didn't have a lot of data behind that. So we started to go with that. The problem we have with this is we've got developers that are trying to build homes. So the smaller lot size they can go, the more homes they can build, which helps with economic development. And meanwhile, we've got this issue of water. We want to make sure that we don't use more water than we have. And so we continue to talk with the state engineer. And then about 11 years ago, we formed a committee in Laramie County to look at the control area and to try to advise and help the state engineer with some of these rules. And at that time, the state engineer hired a company called AMEC to come in and help the committee with and do a study. And so when we were doing that, we, the county commissioners, approached the state engineer and said, hey, this is a perfect opportunity for us to get a little bit better guidance from you guys to help us with this minimum lot size problem. And so the state engineer did just that. He tasked AMEC with coming up with some sort of guidance for us. And at that time, they sent us a memo. So we have referred to this as the AMEC memo. And what they looked at was the recharge rates for different areas within Laramie County, and then set the minimum lot size based on recharge rates and what minimum lot size there would be no negative net effect on the aquifer. And so we have been going with that since that time. And what we tell people is this is the best data we have available, the best science we have available, and this is what we're making our decisions. There's still concerns. Contractors want smaller lot size. We want to make sure we can get the most out of our land, but we also want to make sure that we don't draw down, the best resource that we have. And so from our perspective, the more data we can have, the more studies we can do. I mean, if we can do this every 10 years and say, hey, listen, we made this tweak 10 years ago, it had this effect. So looking at the past, but also looking at the future, I think certainly would be beneficial to county commissioners. I mean, I'm a veterinarian. I don't understand water. So to have that guidance from the state engineer's office would be fantastic. And so we're very much in support of this bill. And if I can make a small comment about the amendment and the amendment to not put in that minimum lot size. I mean, we would love to have the state engineer dictate the minimum lot size. But the state engineer, Gebhardt's comment, he's right. That is our decision. And so certainly that amendment, I think, makes sense to us. And there's other factors that go into that to minimum lot size. I mean, our Department of Health has a minimum lot size that, you can put a septic tank on, et cetera. So certainly understand that amendment and appreciate it. But again, for the bill, would appreciate your support of that today.
Thank you, Mr. Thompson. Commissioner.
Thank you.
Questions for the commissioner? Senator Love.
Mr. Chairman, through you. So as I hear the conversation here, you and I have talked about this before on a number of occasions, but and we had your planning department in the meetings with Secretary or State Engineer's office. And so we've tried to develop this comprehensively. And one of the things your county is witnessing is a sprawl around Cheyenne that's making us look more like one of the Front Range Colorado communities. But this minimum size is what's driving that decision based on what we have as the current information. And the hope is that we'll provide different information that may allow for other resources that can provide for smaller lot size and maybe slow the agricultural consumption of land through development based on those smaller lot sizes.
Yeah, go ahead and keep your comments brief just because we're running out of time. We want to get through this bill. Thank you, sir.
Mr. Chairman, through you, Senator Love, absolutely. Again, it's having the best data available at the time to make these decisions. And yeah, if we can certainly, get this lot size minimum smaller would certainly help with that.
Very good.
Go ahead, Senator.
Follow
Love.
up. So in thinking through that process, if we can put less real estate to a house, there's also the potential it'll drop the cost of housing for Laramie County and the southeast corner.
Mr.
Go ahead.
Chairman, Mr. Chairman, through you, absolutely. And we all know here in Laramie County, we're struggling with housing. Absolutely.
Thank you.
Very good. Thank you, sir. Go ahead, Mr.
Mr.
Short.
Chairman, members of the committee, I'm Robert Short, Commerce County Commissioner and Vice President, Wyoming County Commissioners Association. We stand in support of this bill. One thing that strikes me in the bill that there's maybe just the slightest bit of ambiguity associated with the term of the study and the 15 days granted for the publication of the results of the study. Should the study be conducted and not conclude until the expiration date associated with the appropriation, would then the state engineer's office have enough funds to publish the results of the study? So is there a way to make clarifying language that the monies appropriated are also encompassing the publication of the study as well? Because it says specifically the appropriation is not part of the state engineer's office appropriation on a biennium basis.
Thank you, Commissioner. Senator Crago.
Thank you, Mr. Chairman. I think their amendment takes care of that because the study has to end by, they have a year after that, I think, and that's why they asked for that extra year for the funding to continue.
Senator Crago. Further questions for Commissioner Short? Thank you both for your testimony today. Appreciate it. Further comments, testimony?
Mr. Chairman, Keith Kennedy for the Wyoming Association of Wheat Growers. And we support this bill. Our concern here is that much of the seed wheat that's grown in Wyoming is all grown in the control area or primarily, and much of that's irrigated. And those folks tell me that their pumping costs have gone up because of declining water levels. And so that's one reason that the primary reason that we support this. And with that, I'd welcome your questions.
Thank you very much, Mr. Kennedy. Go ahead.
Mr. Chairman, members of the committee, Kelly Carpenter, Wyoming Farm Bureau Federation. In the interest of time, I will be incredibly brief. We support the bill. It'll be helpful in understanding recharge and water control areas for informed decision-making. With the data gained in the study, we can better protect agricultural water use in these areas as urban sprawl continues. Thanks, and I'll take any questions.
Thank you very much. Questions, committee? Thank you both. Further testimony? Everybody online, Clayton? Okay, we'll close public testimony.
Move the bill.
Been moved by Senator Crago, seconded by Senator Love. Discussion. Senator Crago.
I think I would like to move the amendment proposed by the state engineer's office, except for the amendment on page 2, lines 2 through 4, and then I will follow up and with the good sponsor with the state engineer's office to come up with some suitable language we can bring on the floor.
Been moved and seconded by Senator Crago, seconded by Senator Love. So if I understand this right, basically the amendment is just like it is, accepting page 2, lines 2 through 4. Is that correct, Senator Crago?
That is correct, Mr. Chairman. Thank you.
Yes. Discussion on the amendment. Seeing none, all those in favor of Senator Crago's amendment, say aye.
Aye.
Opposed? Amendment passes. Back on the bill. Further amendments. Discussion.
Question.
Question's been called. Roll call. Go ahead, Clayton.
This is a roll call vote for Senate File 50 as amended. Senator Crago.
Aye.
Senator Love.
Aye.
Senator McEwen.
Aye.
Senator Pearson. Chairman Ide.
No.
Mr. Chairman, that is 4 aye and 1 no.
That's not the only reason. Okay, committee, sorry, I got sidetracked here. Any other business we need to take care of? I'll entertain a motion to adjourn.
Moved.
So moved. We're adjourned. You're where I live. Yep.
Appreciate it.
Yep.